Imagine that you had a performance review, but this performance review was done by a software without any single manager checking it. Like there was no manager input on your performance appraisals. And as a result of that appraisal, you were terminated from your job, or you were demoted, or other sanctions applied. Is that right? Do you think you deserved that punishment? Do you think it was okay? Or do you think something was wrong with that? And as an employer, do you think that was fine? Or do you think you're legally liable for that decision? Today we'll be talking about something very, very interesting, something that has got my heart. AI as your manager, and what it implies or what it means for employee rights and employer responsibility. Hello, it's your girl Mary Mbufe, and welcome to my channel once more here with MI. We're so happy to have you on board. Artificial intelligence is used by many employers, okay? Most of us use it to screen CVs, to conduct performance appraisals, to trigger layoff, to monitor who's doing their job and who's not. And how do we use it particularly? So we know that for screening of CVs, AI can help you, can help the HR to rank CVs, screen them based on the essentials or the non-negotiables of the job, based on the JDs, before a human being gets to interface with them. For monitoring performance appraisals, especially for people that work remotely, there are AI algorithms that are built to monitor how people respond to emails, the number of tasks they complete in a day, the output of the job. They even judge quality by algorithms these days. Yes, they do. Yes, I'm correct, they do. And then they use it also for surveillance. They check how many hours an employee actually stayed in a particular application. They check all these things, and they use these things to actually form part of the appraisal system. So if, for instance, an employee does not stay for 5 hours a day and they complete the job, it doesn't matter, because the algorithm will automatically judge them for not staying 5 hours a day. Meanwhile, they actually completed the task at the time they were expected to complete it. So is that okay? Is that right? Because they could have a pay cut, they could be terminated, laid off for underperformances. Meanwhile, when AI makes decisions on behalf of an organization, when AI makes decisions that are discriminatory, decisions that are wrong, so to say, when AI does that, who is to be blamed? We have seen in recent times that AI softwares that screen CVs, that conduct performance appraisals, all of this can have or can be trained with biased algorithms. And when an AI software is trained with biased algorithms, they can make biased decisions. So now let me give you an example. There was a law case recently. I think it was ongoing as at last year. Not sure that case is concluded yet, but that was in California. Yeah, that was in California. I'm not sure it's concluded yet. And that is between a man named Derek Mobley. I think it's Derek Mobley, and he sued Workday. Workday is a software, like a software provider, all right? So he sued Workday because he's a man of, I think, 40 or over 40 years, but he has been applying for jobs and he has not been getting jobs. Now, he's black, he's African American, he's over 40, and he's disabled. I think that was also because there were There were three things. And he sued Workday that Workday's algorithms were discriminating him based on the fact that he is African American. That's based on race, also based on the fact that he has a disability, and also based on the fact that he is actually 40 plus. Now, this is because he believes that his work experiences and his expertise should have earned him a job, but he has been applying for jobs countless times over the years and he had not gotten any. Now, this case was still in court, I think as of November 2025. So I'm not sure if that case has been ruled yet. So I'm not here to say, oh, it has been ruled in his favor or ruled against him. But what I'm trying to say is the courts, the judge of the court where this case was taken to in California, she actually made it an open case such that any other person that had applied to these organizations that use Workday can actually join him in suing Workday for these discriminations. Now, there is a possibility that a software can, or a company rather, can have no intentions whatsoever to discriminate against applicants, but the software, because of the biases that have been used to train the software algorithm can be biased and make discriminative decisions, on recruitment, on performance, and etc. Now let's analyze this case of Derek. So imagine that 100 companies bought Workday as a HR software platform, and these 100 companies have had the same cases. Now, in the case of Workday, it could be possible that the algorithm was trained with maybe some historical data, which could create historical bias, or maybe some predictive data, which could actually, due to regular use, could actually bring some predictive bias, like the age. It could be possible that based on how these companies use the algorithm or the software, they always went for candidates below the age of 40. Now, if they always do that, the algorithm will be programmed or will be conditioned to want to grade people below 40 years as first, like grade them as the most fit before grading other candidates. Algorithms can be trained and retrained, and another truth is algorithms can have biases based on whoever trained those algorithms, like formed them, for lack of a better word. So let's bring this Derek Mobley's case back home. I mean back to Nigeria. We have Nigerian laws that are against such practices. By such practices, I mean employers allowing algorithms or AIs to make decisions solely without human input. And one I want to read out verbatim: the Nigerian Data Protection Act of 2023, particularly section 37. It says here that a data subject shall not be subjected to a decision based solely on automated processing of personal data that produces legal or similar effects unless there's human intervention. Now, what does this mean? This implies that if your employer allows the software or the AI alone to make decisions regarding your recruitment, that's candidate recruitment, regarding performance appraisals and all of that, it may actually be in contradiction with the data protection law, as we just read section 37 of it. All employers in Nigeria, for instance, I'm going to speak for Nigeria because I'm a Nigerian. All employers in Nigeria, all HR managers, all HROs are supposed to conduct what is called the Data Protection Impact Assessment on every software they are to use before they use them. Coming back, we're going to dive deeper into this topic. We're going to be talking more about the legal aspects. We're going to be talking about how employers can actually mitigate these issues, because AI is here to stay. So how do HR staff members and employers alike mitigate this issue? How do they use software without having these kind of issues? I'm going to be walking us through step-by-step processes on how to achieve this and save the company from any further lawsuits like that of Derek. Now, I don't know how Derek's case is going to turn out. I don't even know if it has been ruled for or against. I'm going to check that before the next video. But if it hasn't, I wish him best of luck, and I wish Workday best of luck. Thank you very much.